Shocking. That's how the attorney representing the PNP's Paul Buchanan has reacted to the Supreme Court ruling, which dismissed attempts to overturn the election result for West Central St. Andrew. The Supreme Court refused an application for judicial review by Mr. Buchanan, arguing, among other things, that the application was not arguable. But Mr. Buchanan's legal team doesn't agree with the ruling and is already planning to appeal.
We are extremely shocked to see the way this matter has been dealt with.
Attorney at law Hugh Wildman on the Supreme Court ruling involving his client, the PNP's Paul Buchanan. Mr. Buchanan lost the West Central St. Andrew seat to Prime Minister Dr. Andrew Holness in the September 3 general election. Mr. Buchanan's legal team insists there were several breaches, but in September, the constituted authority refused an application to void the poll results. The matter was then taken to the Supreme Court. In Monday's ruling, Justice Sonia Wint-Blair said the court could not extend the time set down in laws governing elections. But for Mr. Wildman,
nobody's asking the court to do that. The law is clear. Time does not run against a nullity. If something is a nullity, it means that it never occurred. It is void ab initio. So if the matter had progressed as we had opted to progress to the election trial and to void it, and they made that announcement that the election is void, then time started to run from that time. So I don't understand how the court could have come to this conclusion.
The ruling also stated that the period during which the authority could have applied to the election court has passed, and any application is statute barred. In addition, the time frame outlined in the law is a knockout blow to the success of the application.
Can't be out of time. Within 9 days after the constituted authority ruled not to send it to the election court, he filed an application for leave for judicial review. He came to me and I filed it. The law says he has 14 days to go to the constituted authority, and he went there in 9 days.
Still, the court stated that it's futile to compel the authority to make an application, and there is a need for finality in electoral matters. The court said the threshold test has not been surmounted and the application was not arguable. The constituted authority is an independent public body which decides whether a flawed election should be sent to the election court, which could void results. Mr. Buchanan has outlined several breaches, including double voting.
That person having voted, drop it in the box, come back for another ballot and say that ballot spoiled. I was given another ballot to go and vote by the presiding officer. These are serious breaches. We have examples where you have, that is a key one. Key one is where they had to leave the polling station because mass men jumping over fence in schemas taking over the polling station. You know? The issue here is, which the court should have focused on, are the breaches that were placed before the court sufficient to compel the court to have the constituted authority refer the matter to the election court? Because once we go there, we know the election will be voided. So the questions have not been determined up to now in this judgment.